Hear ye, hear ye.
I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial daddy.
I want to give a big shout out to the 13th Jury Podcast and Brandy.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
Yes. And then I just looked to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, we'll have some coffee.
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Good morning. Good morning. Let me go ahead and turn down my volume because I finished recording the podcast late last night. So I'm sure y'all are going to tell me that my volume is too high. So let me go ahead and turn it down and y'all can let me know. I've got the automatically adjust my mic volume thing. So hello, my friends. Hello, my friends. It has been a week. It has been a weekend. It has been an amazing time. I am glad to see y'all. Okay, y'all are saying it sounds great right now. If it gets loud, if I get loud compared to the court when it starts, just let me know and I can adjust it. Because I can't tell until y'all tell me. Because when I have my settings done for podcast, it's always different when I go do the streaming. Kim R, member for 8 whole months. Hello, Kim R. Hello. Welcome to your 9th month. MLS, hello. Dave, hello. New member, welcome. Hi. Yes. Yes. Amanda Davis, member for 22 whole months. Congratulations, ma'am. What does the kid think? The kid's excited. Yes. So I see all y'all in chat. Yes. So for those who have not been on social media or who have missed it, Chat Daddy and I, he put a ring on it. So he's officially joining the family. Never say never, I guess, because y'all know me. A year ago, I'd have been like, A year ago, I was like, How many times have I said I'm never getting married again? But here I am. But he's amazing. So the kid is excited. He actually, it was really cute. He, the night before he proposed, he called the kid to get his blessing and called my mama to get her blessing. So it was really cute. So yes, never say never. Never say never. But he's excited. Canoni's Baloney. I love that nickname. Canoni's Baloney. Remember for 8 whole months. Hi, everyone. Lovely news, Brandy. Thank you very much. Thank you very much. Yes, he, I hear the 6th marriage is the one that really sticks. Okay, so I've only got a few more until I get there. So it'll be all right. Yeah, that's amazing. Yeah, sure. I know, isn't that sweet? Very, very sweet. I thought it was really sweet. And the kid was like, gave his blessing. He's very excited. So, yeah. Yeah. I mean, well, I don't know. Can you see it? Yeah. So, yay. He's stuck with all of us. Yeah, he's got 32,000 new best friends. So yay, thank you. This is why I started 10 minutes early though, because I was like, everybody's going to want to chat about this for 10 minutes before we can move on to the actual trial stuff. So that's why I figured I'd start a little early. Good morning. Let's see what part-time Bev does today. Yeah, somebody just said on Twitter that court starts at 11, morning break at 11:30, lunch from 12 to 1, 2-minute arguments from the lawyers from 1 to 1:30, and then scheduling till 2. And I was like, that's incredibly accurate. Incredibly accurate. Does he know he's getting 32,000 wives? My sister wives. My sister husbands. Let's see. Sidebar. Oh yeah, there's going to be some sidebars thrown in. Congrats, even Auntie Deb and Melanie Little wished you well 2 days ago. Aw, that's sweet. I'm going to be on with Auntie Deb tonight, and I am so excited because it just so funny. So Auntie Deb is so funny. And it's one of those things where, you know, y'all know how it is with these trials. You need those moments of humor to balance out all the really tragic, sad stuff. So I'm excited. And Auntie Deb is one of my favorites. So I will be on with Auntie Deb tonight at 7 Eastern, I think. So that'll be a lot of fun. That'll be a lot of fun. Good morning. Good morning. So when's the wedding and will it be live streamed so we can be there? I have not thought about it being live streamed. But you know, I might see if we can make that happen. We'll see. We'll see. I hadn't even thought about it. His interviews are so funny. I know. I'm so excited. I'm so excited. Oh my gosh, I've never watched any. Oh, you have to. You have to. Let me get the link so that I'll put it in the chat. So much fun. Let's see. Share. Copy. Okay, there's the link. So that way you have it tonight. Here, I'll pin it up top for a while. So set your reminder so that y'all can be there tonight. It'd be fun. I am Captivating 85, member for 20 whole months. Congratulations, you deserve all the happiness. Thank you so much. Thank you. Thank you, thank you. Yes, live stream it. Call RA, he'll come do it. He would live stream my wedding for me, wouldn't he? That's so funny. And but he can only live stream if he's going to do commentary. Like, he's got to do commentary on everything that happens, and like funny commentary about, you know, how he is. He's so funny. So to make it not, y'all know how I am. I'm not very, like, I don't like to be overly serious or overly sentimental. So I gotta have it funny. Wish Ricky Watson could be here for big news. Me too. You know, it's funny because Ricky Watson, every time I always used to talk about how I'm never getting married again, he would argue with me and tell me that I would end up getting married. And then he, you know, he would volunteer to be our, one of our trial daddies. And he'd say that that was all we needed. He's the best. We miss him dearly. My son just got engaged and they chose May 30th. OMG, I love my future daughter-in-law. It's wedding season. That's amazing. Congratulations. Congratulations. Recovery Act would live stream, record the wedding for you. I need to ask. That would be really funny. RA commentary at the wedding. Oh, wedding brows. No. No. Chat Daddy would see me, he'd see the brows coming down the aisle before he saw anything else, and he'd be like, who's that? Thank you, thank you. Thank you, thank you. Hi, Kaylin. Thank you, ma'am. Thank you. I am excited. I am. Who knew? Uh-oh. Stuff's already happening on Twitter. Court starts at 11 today. I'm getting updates of something. What is happening? Let's see. What's happening? I've got, okay. Housekeeping business. I released a podcast episode last night. So last night is the rest of everything from the March 20th hearing. So that's all on. I rather than trying to put everything, because if I put everything in together, these are ones that I don't want to skimp out on, because these are all of these motions are all of the ones that are really going to shape what we see in the next trial. So I wanted to make sure that we get all of that, all of the important stuff in there. So some of them I did kind of skip through that weren't super important, or that they kind of agreed on or whatever, but the ones that had actual arguments or fireworks, whatever, all of those are in there. So the episode I released last night, I decided to go ahead and release 2 episodes this week. So I did, so that it wouldn't be like a super long episode. So I did 1 episode that I released last night. That's everything else from the May, look at me skipping ahead, from the March 20th hearing. And then the episode later in the week will be everything from today's hearing and anything else that happens this week. So you get a bonus episode this week. Oh, the new third-party culprit documents are out, so we can take a look at those too. How many motions are we still waiting for anti-BEP to rule out? A lot. All of the ones from last week that weren't agreed on have not been ruled on yet. And that's a lot. And then this week we've got whatever else. I have to change the orientation of my straw. And then this week we've got, she said, the outstanding issues we're going to see. And yes, she still has not ruled on the evidentiary hearing. So she had said that she doesn't want to delay the trial because she has the help with getting all the jurors in, because they've got like, I think 2,000 jurors that are going to be coming in or something crazy like that. Not all of them will be for the Karen Read case, but most of them will be. So they are bringing in a ton of people because there's been so much publicity on it. They know it's going to be a while before they can seat the jury. So jury selection is actually supposed to start on the 1st. So that's like a week from today, which is wild. That jury selection is supposed to start a week from today, and we've still got so many outstanding issues right now. So the motion to dismiss, she's evidently not going to have the evidentiary hearing. I don't see how you can get out of having an evidentiary hearing with all the stuff that's happened, but there's a lot of stuff that I don't understand from Canton, Massachusetts. So so whatever. I don't know. Hello. I give jury selection 2 weeks. Didn't it take about 2 weeks last time? I'd have to go back and look at my chart because it started April, 14th-ish last year. I have a feeling like the trial date is going to end up starting almost exactly when it did last year, which is kind of crazy, right? So we'll see. Peter thinks she did waive her attorney-client privilege for their new motion. See, I have not had a chance yet to see any of the lawyers' takes on that, and I posted it on Twitter, and I asked the question. I was like, how does this waive, how does this waive attorney-client privilege? And I've got it bookmarked so I can go back and read it. I haven't had a chance to yet though, because I wanted to hear attorneys' takes on that in Massachusetts. I haven't got to watch Peter yet. The only things I've seen so far are there were a couple people that were saying that the specific conversations that she's mentioning, the ones that were specifically about her saying, did I say this, or did, like when she's saying, I said this to him, and she's like, did I, what if I hit him, or what if I did whatever? And he said, then you have culpability. Somebody said that, oh, the sprinklers came on. I was like, what is that? Somebody said that those specific conversations would be potentially subject to like waiving privilege or whatever, but that it would be very specific to just those. So I don't know. I'm curious to hear the legal perspective on that. So, but I've also heard a bunch of people saying that they don't think that Bev will approve that, but we didn't think she's going to approve the dog behavior dude either. So who knows? PJ, hello, member 18 whole months. Glad to be here. Congrats to our precious Brady. Thank you so much. Thank you. Thank you. I appreciate it. I appreciate it. April 15th, tax day. Is that when it started? Oh, that makes, oh crap, taxes. I gotta get on that. Hello. Pretty sure it was 2 weeks last time. I think it'll take longer. I was thinking that too. I thought it was about 2 weeks, and I think it'll take longer this time too, which is actually good because she had said, they had asked to stay, like to delay it until they heard back about the appeal, and she had said that she wasn't going to delay the start of jury selection, but she wouldn't swear them in yet. So I'm thinking that if it took 2 weeks last time, it's going to take longer this time because there's been so much more publicity on it this time, and with the documentary just coming out. I think it'll take longer. He did a nice short video explaining. I love Peter's videos. Sheila says, lawyer here. My opinion is that she has waived it in a very limited way. Those conversations about that specific conversation is fair game, but nothing else. Yeah, see, that's what I had heard from another attorney, Sheila. That's what I had heard from another one. So that's right on track with that. It would be very limited to just those. And that was one of the things that was interesting to me though, because I have to go back and read it, but it said something about all communications, text, emails, whatever, through that. But it was but it couldn't be all because it would be very limited. So Brennan is doing the conversation she had with Yannetti or in a text message. I don't think a lawyer is going to say that in text. Good point. That's a good point. That's a very good point. Kiefer, thank you so much. Thank you. Thank you. Thank you. Thank you. Let's go ahead and block that person. Oh, yep, y'all already got it. Oh, my mods are on top of things. Y'all are so good. Oh, y'all get to it before I even can. I think she will approve anything that could make the defense and their media coverage look bad. Yeah. Surprise! Surprise! Tax is sneaking up on the nearest. Every time I file an extension every single time. Every single time I file an extension. And then I get to the extension, I'm like, crap. Trolls have too much time. Wouldn't it be nice to have that extra time? How do they find it? How do they find it? Carl Steinbeck and Microdots made a good case for an alibi defense based on the Commonwealth's own timeline. You know, that was something that was interesting too. And I put this in the podcast that I released last night. The testimony from Proctor from before said that she had arrived home at 12:34. She connected to the Wi-Fi at 12:36, and now he said in that hearing the other day that at 12:32, that's when they think that they say that the collision, I think is what he called it, happened. So that's one of the things I put in the podcast yesterday, is like, there, you know, that's something that they're going to have to explain if that's the new, you know, if that's the new theory. So, let me see. We've got our OnlyFan. Let me go ahead and get our OnlyFan up and going, up and moving, ready for the day. Oops, I don't like that. Hold on. Stop screen. Present. Share screen. Share. Oops. Okay. I think. Wait, did I pause it or is the fan just off? No, it's not paused. Like, how do we know that, like, life is moving on if the fan's not on? I'm so confused. This is really throwing me off. I've been sitting here for, like, these last 4 minutes trying to figure out how to unpause this, and it's not paused. The fan is just off, and now I feel like my whole life is a lie. All right. I don't know what to do with the fan's not on. We'll just cover it so that we don't know. Will Lucy be a bridesmaid? I don't know. Maybe she'll be the ring bearer. Hello, Aussie. Hello. People hate my polls normally because I'll make them pick, like, the last poll. Like last week we did one that was making people pick somebody to go cross country with, and it was like you had to pick between like somebody riding shotgun with you. You had to pick between, like, Brennan, Lally, Proctor, and Buchanan together, or who was the other one? Who was the other one? I don't remember who the other one was. I don't remember. Thank you, thank you. Thank you, thank you. Gresha says, I really don't understand why Bev has made such a huge deal about AJ's forgetting to file the receipt of payment to ARCA and miscommunication that led to the defense's misrepresentation about the payment. Here's my thing. Okay, if she's going to make a huge deal about that, I just wish that same energy were spent on every single time Brennan makes a misrepresentation to the to the court, because I feel like if she's going to give that whole speech about candor to the court, she's not wrong about candor to the court being a big deal, but she needs to have that same energy every single time Brennan gets up there with his BS. And that's what makes it really frustrating to watch this, because if there were a balanced view or a balanced treatment of the two sides, it would be a little bit easier to, it almost puts you like in defensive mode sometimes, because you're like, okay, even if you agree with something that she's saying, like yeah, they screwed up. They did. But it almost makes you not even care that they screwed up, because you're like, bro, like where's this energy for all the lies that Brennan keeps telling? And that's what's really frustrating to me about this. Like really frustrating. Be Kind Tiger, hello. As wedding plan, I need to know colors for all of us bridesmaids and ushers to coordinate. I haven't even thought that far through yet. So as soon as I figure it out, I will let you know. I will let you know. Thank you, Be Kind Tiger. Maybe we'll have polls. We'll just, has anybody ever planned a whole wedding on YouTube? We'll just do that. Every time I need to make a decision, I'll just go live and we'll do polls. Northeast Whitewater, hello. How will this trial deal with Proctor's investigation? It has come up at some point. It has to come up at some point. What will the jury know about Proctor? Well, I'm expecting to hear more about that today, because Brennan is planning on trying to have certain things kept out. He doesn't want the jury to hear that Proctor was fired. He doesn't want basically anything that the defense definitely wants to use, Brennan doesn't want them to use. So I expect to hear more about that today. So we'll see. We'll see. Good morning. Good morning. Thank you. Hello, Bree. Oh yeah, I forgot you got some new hardware. How was typing with that new ring? Thank you. It's funny because I came to bed late last night and Chat Daddy was like, he said the same thing. He was like, is your hand tired from holding it while you're typing? So funny. All those new fun things that you get to laugh and joke about when you're newly off the market, or whatever, however you say it, newly engaged. Oh yeah, Bev was the other one. Yep, we had to pick between. Bev was the other one for the road trip, and I think Bev ended up winning, didn't she? I think most people chose Bev, because I mean nobody's going to choose Brennan. Like I think there was like one or two people who chose Brennan, but then in chat they were like, no, that was me. I did it on accident. I didn't mean to hit that one. So there's that. But I think most people chose Bev, and they were hoping to just give her some White Claws and let her pass out so you can drive in peace. So. Candor to the court might unleash a bunch of bad words. Yeah. 2 words. Do it. What time is court? It's supposed to start at 11, so it should be starting any minute. And I keep trying to make sure that I'm not paused because the fan's not on, and that just throws my world into a tizzy. For he just say wedding. Yeah. Yeah, who knew? I know this. It won't be during football season, so there's that. Is today the day that Bev denies the defense's motion to dismiss and she won't have an evidentiary hearing? Probably. Because I think she's wanting to wrap up she said all of the outstanding stuff today. So I think that today is going to be the day that she tries to get everything done, because jury selection starts on Monday. Which is wild. I'm late to, oh yeah. I showed it earlier. This is the last time I'm showing it. From now on, y'all got to rewind. Thank you, thank you, thank you. We could all dress up as characters from the trial for the wedding. Okay, Could you imagine me getting married with my Letitia hair? How is it that we, the public, can know more details than the jury is supposed to know? Brennan definitely knows the value of good defense. I hope is, it's funny because I have said before that Brennan is prosecuting this in a very defense attorney way, and which is interesting, but also really frustrating in a lot of ways. So, I don't know. He also uses the media. He uses the media big time. Which is funny because he accuses, the defense of doing that, but he does it. So the hypocrisy of him, you know what triggers me about him? And I've said this before. What triggers me about him is that Brennan behaves exactly how the trolls behave. They attack without facts and then accuse you of doing the things that they themselves are doing. And that's why I don't like Brennan, because he behaves the same way that the trolls do, and that is childish and annoying. And I feel like the courtroom is not the place to be childish and annoying. Leave that to Twitter. Tosh gifted membership. Thank you so much. Thank you. Thank you. Thank you. Thank you. Brennan is a manipulator big time. Big time. He's a glorified Twitter troll. And he gets a lot of his information off of Twitter, which is really kind of scary if you think about it. Because I'm pretty sure that's where he got the clip that he quoted from my interview. I'm pretty sure that's where he got it. I got married during football season, Florida Georgia weekend, actually. Married on Friday, football Saturday, and left for honeymoon. That's actually that would actually be fun, because we went to the Georgia Florida game this last year, and we're going to go again this year. So much fun. That's a fun game. Lawyer, said that Marcy should be in trouble for his press release for the trial. Yeah, and I was so glad. So, and that happened at Peter did that at the perfect time too, because I had compared all the things that Brennan was saying. I had compared that to, where he's saying, oh, the defense shouldn't be doing this and they shouldn't be doing this. I compared that. And I took clips from Marcy's hostage video, and I compared what he was saying shouldn't be happening to exactly what Marcy did in an episode of the podcast. And then I saw that Peter had said, everybody was telling him, you have to watch this, you have to watch this after that motion came out. So he watched it, and I ended up watching his stuff, and I was so glad to see it, because I was like, because it's one thing for me to have my opinions on stuff, but then seeing it from, attorneys that I trust their opinions and their perspectives is a whole different thing. So how did he propose? I will tell y'all that story one day. I want to stay in my little happy bubble for now, though. It was a perfect proposal, I'll say that, but I want to stay in my little, I gotta keep some stuff private. Ooh, here we go.
Good morning, Your Honor. Hank Brennan for the Cloud Bar. Good morning, Your Honor. Al Jackson. Good morning, Mr. Jackson. Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed. Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Mr. Leslie.
Good morning, Judge. David Yannick for County.
Good morning, Mr. Nettie. Good morning, Ms. Reed. All right, so before we begin, Mr. Jackson, when we left the other day when we were talking about Michael Easter, I gave you the opportunity to get some authority on expert testimony in voter defense. Were you able to do that?
We were.
Do you have something to file?
Yes, it was filed yesterday. I do have a courtesy copy for the clerk.
Okay, thank you. And I can, if the court wishes, we can take that on. That's going to suffice.
I think so. I'll take a look at it.
It's got everything in it that I would say orally anyway, but if the court has any questions, I'm happy to answer any questions.
All right. Thank you.
Where's our court reporter?
So, thank you. So, similarly, regarding the third-party culprit argument the other day, Ms. Giannetti, I see you did file something late yesterday, so I got that. I'm just wondering if either the Commonwealth or the defendant want to be heard on that.
The Commonwealth does.
Okay, so I'll hear you, Mr. Brennan.
Your Honor asked for a proffer from the defense regarding third-party culprit, alternatively, evidence that would be separate regarding third-party culprit aspect of Bowdoin. We received some information from the defense that does not distinguish whether their intention is that it applies to third-party culprit or whether it applies to a third-party culprit aspect of Bowdoin. Those concepts are logically and legally distinct. Regardless, when you look at the proffer by the defense, it is insufficient and inadequate for both third-party culprit and for any third-party culprit aspect of Bowdoin. Two different analyses, but the evidence is equally feeble for both. Relative to third-party culprit evidence, there are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit evidence. Not to iterate the law because it is clear, but there must be relevance, there must be a substantial nexus between the claims of the defense and the third-party culprit theory. They provided us 3 people that they identify as third-party culprits. It's helpful just for a quick synopsis of the history. In this case, prior to the first trial, the defense never identified a third-party culprit. At some point, the defendant herself said that they knew who the third-party culprit was, and recently the position of the defense has shifted that they don't know and don't need to know. Now, the law accommodates specifically identifying somebody. It also accommodates general, but it has to have specificity in the complaint. There has to be a motive, an opportunity, and an intention. There has to be evidence that draws the correlation. It can't be bad character, speculative, or just putting out information that's negative towards a witness so that that can backdoor prior bad acts against a witness and be used for a different purpose. They identified one person, Colin Albert, and in their proffer, what they offer, number one, and it's important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up to January 29, 2022. Now, other than maybe on social media or in interviews with the defendant and national broadcast, there's no evidence of that. There is no evidence that's going to be admitted at this trial that shows there was a feud between Colin Albert and John O'Keefe. There is no evidence that there was any hostility between Colin Albert and John O'Keefe. There's no evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence of any motive, of any intention, or of any opportunity whatsoever. In fact, the evidence is that Colin Albert was not even at 34 Fairview at the time John O'Keefe arrived there on January 29, 2022. And so simply saying it is not evidence. And an attorney should not be allowed to confront a witness about an allegation that has no factual basis for them to then have to defend the accusation. The prejudice then seeps to the jury, and the Commonwealth is in the position of having to disprove a claim that had no basis to begin with. The second claim that they make regarding Colin Albert is that he had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face. There is no basis for those claims. There is no witness for those claims. There's no information regarding those claims. I understand there may have been a party where there was beer cans, but there was no Colin Albert. So to attribute a situation or an incident to him, the defense would need some good faith proof, actual proof, fact, that this actually happened. And there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof is because it didn't happen. So again, the defense asks for an invitation to simply cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor and the government has to disprove it. That is not the cloth that third-party culprit is made from. Regarding the suggestion that there was some type of feud or tough relationship, I saw on a video that there were two radio personalities, and I have the clip, who spoke and met with Karen Read, and during the conversations, at least they relate, that there was some claims about a drug issue, and according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Read. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. And so what we know is there is no history of animosity between Colin Albert and John O'Keefe. We know that there was no animosity.
Hold on. Did he just use a radio personality's opinion as proof in court? Is that what he just did? Am I crazy? He just said that Karen Read did a interview with two radio personalities and the drug rumors came up. We've all heard it. I don't report on it because it's a rumor. I've never been able to substantiate it, so I don't report on it, but we've all heard it. And according to the interviewers, they said that the story is false and people are being dramatic. So he just used that as his proof in court?
Between his family and John O'Keefe. The only event known is that at some point, Colin Albert's younger brother ran across John's lawn. Mr. O'Keefe supposedly yelled at him and then bought him candy as an apology. That's it. So we have an alleged third-party culprit, a very strong claim, with no evidence. No motive, no opportunity, not even present at the time that this alleged collision occurred. And so in that absence of evidence, it's not even feasible. Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility. Really, it seemed to be a backdoor way to tarnish his reputation and then bind him with other people the defense would like to attack, to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped, and inevitably it turns out that picture, and I think the exhibits were introduced at trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had scraped knuckles, subsequently, because he may have done a video that some use would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce alleged aggression or prior bad acts, but there's no bind whatsoever. The second person that the defense would like to identify as a third-party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it. And even if it was so, has nothing to do with this case. Known as a bully. So rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing. They suggest, and I'm not sure what the basis for this is, that he was drinking heavily that day when he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just general inflammatory accusations about character. They say he was a trained boxer because when he worked out, he boxed and he was engaged in charity events, some dating back to 2003. By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general suggestion of strength and distorted into a hopefully perceived sense of violence that it has no root at all, no root. They went as far to say he was investigated by BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There is no sustained findings that are known to the Commonwealth against Brian Albert in Internal Affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact. I'll say, even though it is off base entirely, it has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations by the defense. In fact, I would say it's not important or admissible. You can't bolster the good character of a witness, but to simply make suggestions of bad character is not any root or tethering to this case specifically. Instead of bad character, Brian Albert was a two-time recipient of the George Hanner Award, has many, many medals of honor from the Boston Police Department.
Decorated
That is
dude.
not the issue. They suggest that he was involved. So they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe. And other than being at the bar that night and Mr. O'Keefe and Miss Reed pulling in front of his property that night, there is no association between the two. They say he's present at the scene of death. By all evidence, Mr. O'Keefe died feet from the street, near the flagpole in front of 34 Fairview. So that's a little bit broad. He wasn't present at the scene of the death. He wasn't there. That happened out front on the front yard near the flagpole, about 70 feet from his house. The body was found feet from his front door, arguably, okay, 70 feet, 75 feet. He admits to being home. He doesn't have to admit he was home. Now, here is another claim without any evidence whatsoever. The defense states emphatically, computer forensic data overwhelmingly establishes O'Keefe entered Albert's house. I haven't seen that evidence. Based on what? So if they're going to make an offer of proof to the court and they're going to make claims to substantiate this theory, they have to have proof of it.
That's the
And in their
stairs.
motion, I see no
and all
proof
that.
whatsoever that overwhelmingly establishes John O'Keefe went into the Albert house. In fact, what we see is the opposite. In the past trial, numerous people were called. Every single person that was asked stated they did not see John O'Keefe enter that home. Every single person. Now, whether you believe it or not is irrelevant. What's relevant is there's nothing to the opposite. There's an absence of evidence to the opposite. In fact, the phone data and the Waze data in the GPS and all the data puts John O'Keefe at the front yard, not in the house. So if they're asking the court to make a finding of substantial link and substantial proof that John O'Keefe was in the house, they have to actually give you the facts and the science and the data to support that, and I don't expect that will happen. They add that there is going to be expert testimony that the scratch on John O'Keefe's arm was from an animal or a large dog, and because Brian Albert had a dog in the house, there was some type of inference. Dr. Russell has already testified at the Lanigan hearing that she's not saying that those bite marks were from Chloe. Although it has not been decided by the court, Dr. Crosby has done molds that show that the teeth comparison is totally an opposite. And so even the defense is not saying, as I see from the disclosures, that Chloe bit John O'Keefe. Their version, which we don't agree with, is that a large animal or a dog caused these wounds. They don't say where, they don't say when, they don't say how. And so that is not a link so that Brian Albert becomes a third-party culprit. Finally, in a way to try to create some type of traction against Brian Albert, they associate him with Brian Higgins because they spent the day together, because Brian Higgins, according to them, was rebuffed because of phone calls at night. All of these general claims with no fact predicate rely on innuendo, surmise, speculation, or just the creation of an inference that does not exist. There is no evidence Brian Albert had any motive whatsoever to harm John O'Keefe. None. There is not one witness, there's not one statement that Brian Albert had any animus whatsoever towards John O'Keefe. None. He did not have the motive, he did not have the opportunity, and there is no evidence that he was involved in any way in the alleged collision that happened in the front of his yard that night. Finally, the defense turns to Mr. Higgins. Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information, and I would suggest don't tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed had kissed Mr. Higgins at John's house. That seems to be corroborated in the text messages. According to the text messages, Mr. Higgins essentially says that Miss Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Miss Reed went to Mr. Higgins' house. And so there was some interest, it would appear from the text messages, between the two. Mutual, at best. There's a plethora of text messages where Miss Reed is pursuing Mr. Higgins, looking for his time, looking for his intention. In one, she says, of basically begging him to come over. Do you like me? Come over to my house. There are text messages talking about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them. What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe. The fact that they are texting together and later that night he sends a text message because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship, is not evidence of motive. And all.
Okay, but also say, okay, so here's where this is going to be up to the jury and not Hank. Saying that the romantic text between Karen and Higgins don't give any kind of motive. Okay, but like last week you were just saying that Karen's motive, like part of her motive was that there was, you know, that Bella's mom lived down the street and that she thought that he was going to see Bella's mom, that there was an issue there or whatever. Like that's the whole thing that happened where AJ got up there was like, you know, you need to at least have some of the facts right. So that's going to be up to the jury to decide on motive, because it's saying that that's a stretch, but that, you know, the whole Bella's mom thing is kind of disingenuous.
All these text messages, you never see any animosity towards John O'Keefe. Mr. Higgins' text messages are virtually all kind towards John O'Keefe. It's uncomfortable, it's an awkward situation because both of them appear to be deceptive as it relates to John O'Keefe, but there is no vengeance, there is no anger. And so the suggestion that there is a motive because there was flirtatious text messages to then kill the man is beyond the pale. It's beyond any logical connection that would support third-party culprit. Brian Higgins sent a text message saying to John O'Keefe, asking if he was coming to the home that night, and they then attached the word he lured them to the house. I mean, we do look at this evidence not in a vacuum, but logically and realistically. Not knowing that Karen Reed was not going to come in when they arrived at the house, is it reasonable, is it rational, is it lucid to think that that Mr. Higgins was inviting them both over to the house, not knowing only one of them would get out of the car? Is the suggestion that Mr. Higgins was going to kill both of them? Or he was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways? The absurdity of the relationship between the claim and reality is so great that it will just run rampant through this trial. It will be unrelated, speculative, shotgun approach to claims that the witness will spend their time trying to explain and defend. It will distract the jury, and it will serve the purpose, which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from. And that attempt to divert anybody but the defendant is the attempt here. That's why we have three, we don't know who, but three potential third-party culprit evidences with absolutely fragile evidence. It's feeble. As their support, what they offer is they believe Mr. Higgins lied because he went to the Canton Police Department to do administrative work, and I think the evidence is clear that he had cars that he parked there as part of his job that he needed to clean off, so they are parsing words in an attempt to create a basis that doesn't exist. That there are calls between Mr. Albert and Mr. Higgins later that night, so what? They have no evidence that either of them spoke to each other. They have no evidence of conversations. They have no evidence of a conspiracy. They have no evidence of a cover-up. They have no evidence of a weapon. What we know is John O'Keefe never went in the home. And so to try to create this image based on obscure facts is not the substance that's required under third-party culprit. I know third-party culprit is a time-honored tradition and is a broad latitude, but it's not endless. It can't prejudice the Commonwealth. It can't distract the jury. It can't be based on fiction. It has to be based on an identifiable theory. The cases that have allowed third-party culprit that have been reported have actual people who could be a third-party culprit, who actually have relationships to the scene or the crime or the deceased. In this case, an attempt to call Mr. Higgins a liar or create fictions about what they think he could have been doing or guessing what they want him to do is not evidence. 9 people testified John never came into the house. 9 people. There is no overwhelming evidence or any evidence he went into the house. There is no evidence of motive on any of these 3 people they identified. They've had, before the last trial, the entire trial, and was aptly pointed out, no request for a third-party culprit instruction. And then they had since then to make an actual proffer that people actually have the motive, opportunity, and intent to do this. That there's actual evidence that there's this alternative theory, and they failed to do it. To have the defense go through a trial, distract the jury, attack the reputation and character of the witnesses, and then not even ask for an instruction at the end. It evidenced the fact that there is no basis for a third-party culprit. Now, separately, third-party culprit is part of Bowdoin. Even if the defense at the end does not warrant an instruction, I recognize that challenging the police investigation is virtually an entitlement of a defense. How they do it and the extent they can do it is a different story. Simply because they have an attack on the police investigation does not let them use third parties as part of that. And so the standard, Silva Santiago, is very clear, it's cited by almost every case, is that there has to be something the police didn't do at the time that they knew about and should have done. So at the time the police did their investigation as being criticized, they would have had to have known about a potential third-party culprit or third-party culprit evidence and didn't pursue it. And that's where the defense argument utterly fails here. Because at the time the police were doing this investigation, what they knew is that John O'Keefe was on the front lawn of 34 Fairview near the street. They knew that he was dying or is dead. And a number of witnesses knew that Miss Reed was saying, I hit him, I hit him, I hit him. A number of witnesses. Shortly thereafter, what the police knew is that Miss Reed's taillight was cracked. And shortly after, what they learned and knew after they got her car is that part of her taillight was missing. So at that time when they were doing their investigation, there was no claim of dog bites. That came months and months later. They went to 34 Fairview and they spoke to the owner, according to the witness testimony. And everything seemed appropriate. Concerned, confused, no blood, no scratches, no cover-up, no turned over furniture. There was nothing that would have alerted the police officers that there was any road to follow other than the road they followed. Now they can be criticized for plastic cups or leaf blowers, but that's different. That's different. In order to have third-party culprit under Bowden, the police would have to have known that there was information that targeted or pointed out a different person, and they didn't pursue it. So in the cases cited by both the Commonwealth and the defense, there are a number of cases that talk about information that was known to police at the time they were investigating and they failed to pursue it. That is not this case. That is not this case. There is nothing in any of these proffers that show actual evidence that the police knew of these later third-party culprit claims by the defense, or they knew at the time they were doing this investigation that there was any other lead. And likely the reason was because there wasn't. The evidence for a reasonable police officer pointed towards the statements, towards the car, towards the light, and that was followed up, which led to DNA and hair and all the other evidence that followed, the data. And so, as a concession to the defense, they don't simply get to bring in third-party culprit through Bowden because they failed in the instant case to show a third-party culprit.
Put him at 1.25.
And mindful that if they do raise Bowden, whether they get instruction or not, it is broad. And that means the police, including any police they would call in this case, or we would call, is entitled then to share their state of mind why they did not do something. That can open doors to inadmissible evidence, privileged materials. The state of mind of the officer is relevant if they make it relevant. So we should not engage in a process where we allow witnesses to be asked questions with no ability of the defense to follow up those questions with actual proof. We should not engage in a process where witnesses, their character is attacked when it has no relationship whatsoever to this crime. And witnesses shouldn't be put through the ordeal of defending themselves based on generalizations about supposedly being violent or having a temper. There needs to be that nexus, and it fails. It is beyond feeble. And so I ask Your Honor not to allow third-party culprit in the instant, and you should not allow it as part of Bowden.
Okay, let me see if this other feed sounds louder. I have it boosted as high as it'll go. It's about the same. I mean,
Yes.
Your Honor, the Commonwealth's motion raises three interconnected
actually
issues,
louder.
not just two. I believe that two of those were conflated by the Commonwealth. I'd like to separate them out. The first issue is the introduction or admissibility of evidence relevant to show that somebody else harmed John O'Keefe. The second issue, which I think was conflated with the first, is whether after the introduction of such evidence, the defense is allowed to argue that a specific person or persons caused John O'Keefe's death. And then the third issue is whether the police properly investigated this matter in light of the information that they had, or information they could have obtained or failed to follow up on to show that somebody else caused John O'Keefe's death. Regarding the first issue, which Mr. Brennan spent a lot of this argument on, there is ample evidence tending to show that somebody else caused John O'Keefe's death. In our opposition, we have cataloged the evidence against each of the potential third-party culprits that we named the last time we were in court. Each one of them had a motive and an opportunity to harm John O'Keefe. The investigators in this case had evidence that pointed to Brian Albert. Brian Albert is a violent man. He was not only a boxer who punched people in the ring, he was also a violent drunk who sucker punched other police officers. Those police officers are on our witness list. He's been investigated by the Boston Police Internal Affairs for having done so. There are many police officers listening to this argument right now who are nodding their heads. We've heard from many of them. It's undisputed that Brian Albert was present at the scene of the crime. It was his house. He claims to have been sleeping merely several feet away from where John O'Keefe's lifeless body was later found. There is evidence that John O'Keefe entered Brian Albert's house. The Commonwealth may not agree with that interpretation of the evidence, but it exists. It's a live issue at trial. At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up. He testified to that. He was at the hillside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard, where Mr. Brennan claims that he was at the relevant time period. That day and night, Brian Albert was attached at the hip to his close friend, Brian Higgins. This was the night that after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night. Higgins had expressed his interest, but it went nowhere. And it went nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him. She stopped returning his messages. Brian Higgins was liquored up that night as well. They're both very large men. The court saw them on the video. Friends who drank the entire day and night, and they were waiting in the house for Mr. O'Keefe to arrive. Mr. O'Keefe ended up dead because he went to Brian Albert's house. After Brian Higgins left, Brian Albert maintained contact with him. At 2:22 in the morning, the two of them were exchanging phone calls to check in with each other just a couple of hours after Mr. O'Keefe was mortally attacked. Mr. O'Keefe had dog bites and or scratches on his arm consistent with a dog or an animal attack. Brian Albert had a large German Shepherd who had attacked and injured somebody in the past. It all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect. And I'm sure the court remembers the words in a text message of now ex-trooper Michael Proctor, the lead investigator who's now been fired as a result, in part, of being biased in this investigation. I would point out also that when Mr. O'Keefe was in the house, both Brian Albert and Brian Higgins were unaccounted for, according to the testimony. With regard to Michael Proctor's words, he was asked specifically if the homeowner would catch any grief for having a deceased person on his front yard, and Michael Proctor said, nope, the homeowner is a Boston cop too. The message was clear. If you're a suspect, you get fully investigated unless you're on the right side of the blue wall. If you're a police officer, you get a pass. Now, In addition to the 2:22 a.m. phone calls with Higgins, there's other consciousness of guilt evidence implicating Brian Albert. And I would note, this is not something that Mr. Brennan addressed in his argument. He didn't talk about the consciousness of guilt evidence. Despite a massive police presence on his front yard, just feet from his bedroom, Brian Albert never came out to speak with investigators. And it's worth noting, it's worth stressing, that Brian Albert was a first responder. He chose to ignore his duty to help somebody in need and instead stayed in his bedroom. And Brian Albert's dog, the family dog, a member of the family for 7 years, Brian Albert got rid of the dog, shipped it to another state, only after it was made known in court that the defense was alleging that the dog had been involved in the attack on John O'Keefe. We showed photos of John O'Keefe's arm in a public hearing where it was clear to any unbiased observer that Mr. O'Keefe suffered those particular wounds from a dog or animal attack. Brian Albert responds to that allegation by essentially divorcing his family from their beloved dog, whom they had had for 7 years and certainly considered to be a member of the family. In the aftermath of John O'Keefe's death, Brian Albert went so far as to send that family member to another state. That's enough evidence to point to Brian Albert as a potential third-party culprit in this case. It's evidence that he had the motive, intent, and opportunity to hurt John O'Keefe. Brian Higgins is another potential third-party culprit. Like Brian Albert, Brian Higgins was present at the scene of the crime. He was there at the relevant time, in the house, again, unaccounted for, at the same time John O'Keefe would have been there. Brian Albert had cause to back up his friend, but it was Higgins himself who was the one who had been flirting with Ms. Reed in the weeks leading up to January 29th. He testified that she kissed him goodbye after they had watched an NFL playoff game at a get-together not long before January 29th. He testified that she had visited him at his apartment after that, but he acknowledged that their text exchange and all contact between them ended, and Ms. Reed was the one to end the contact. She stopped responding to him. She no longer gave him any attention. So we come to January 28th. Brian Higgins sees Ms. Reed in person, but she's not alone. She's instead with Mr. O'Keefe. Ms. Reed and Mr. O'Keefe are affectionate with each other that night, and Higgins is there to see it, as is Brian Albert. There's evidence that Mr. Higgins wants Mr. O'Keefe to come to the Alberts' house that night. In fact, he appears fixated on making sure that Mr. O'Keefe went there. In the waterfall video, Your Honor, you will see that Higgins motions to Mr. O'Keefe when they're leaving. And Higgins even texts him directly after that to make sure that he was coming. Then Higgins goes to the Albert home. John O'Keefe goes inside. Higgins is there waiting for him, with both the motive and now the opportunity to hurt John O'Keefe. Like Brian Albert, there's evidence of his consciousness of guilt as well. After a long day of driving and drinking, Higgins leaves Brian Albert's residence, does not go home. Instead, he goes to the Canton Police in the early morning hours. He initially claims he went there to do administrative work. He changed that testimony at trial to him going there to move a vehicle. But he's always maintained, including in the first trial, that he never called anyone. We've learned since that trial that Higgins is at the station on video making a phone call. So I suppose the question is, why did he lie about that? The jury in this trial should be entitled to consider the answer to that question. And of course, the police never investigated who he was calling or what he said or who was calling him. Then he goes home and he still stays up. And at 2:22 in the morning, he's speaking by phone with Brian Albert. And he claims that they didn't, but the phone records don't lie. And this notion that these two men are somehow able to butt dial and butt answer each other is just ridiculous. And there's more consciousness of guilt evidence with regard to Higgins. When he realizes that investigators might be interested in the contents of his phone to see what evidence might be on it, he demonstrates consciousness of guilt by getting rid of his SIM card and the phone itself. And how he got rid of it was extraordinary and demonstrates just how badly he wanted to keep that information out of the hands of investigators. He admitted to breaking the SIM card into and making a special trip to a military base to put this tiny object, the size of about a thumbnail, into a large dumpster. It wasn't enough to throw it in a waste paper basket or a trash bin outside the local Dunkin' Donuts. Instead, he went through security at a military base and secretly tossed this tiny broken SIM card into a dumpster. He made sure that investigators would never know what's on his phone, and he admitted to that at the first trial. And of course, the investigators in this case, including the lead investigator, former trooper Michael Proctor, never showed any interest in Higgins' phone. Higgins nonetheless accomplished his goal of keeping the contents of the phone out of the hands of the defense in this case. That's powerful evidence of motive, intent, opportunity, and consciousness of guilt of Brian Higgins. As Mr. Brennan acknowledges, all doubt should be resolved in favor of the admission of third-party culprit evidence, linking him to the harm caused to John O'Keefe. And finally, Colin Albert is a potential suspect. He had been in a feud with John O'Keefe. He'd thrown beer cans in his bushes, told him to F off. We have a good faith basis to claim that. This is the same Colin Albert who testified under oath he had never been in a fight in his life, yet there are videos of him clearly desperate to beat up others. The same Colin Albert who had scraped up knuckles just a few weeks after John O'Keefe's death. Those knuckles looked consistent with an attack on somebody. The photographs that Mr. Brennan references that were allegedly before that photo had no metadata. We can't confirm when those were taken. Mr. Brennan wants us to just accept the testimony that they were taken before the scraped up knuckles photo. We don't buy it. We don't think a jury will buy it. When John O'Keefe was found, he had two black eyes looking like he had been punched in the face. Colin Albert was at his uncle's house with both his uncle and Brian Higgins, disliking Mr. O'Keefe for a different reason, but disliking him nonetheless. And it's suspicious that Colin Albert's name was purposefully omitted out of the police reports. There was no indication in any police report provided to the defense in the first few months of this investigation that Colin Albert was anywhere close to 34 Fairview, his uncle's house, on January 29th. In fact, there's no indication in those police reports that Colin Albert even existed. Initially, we didn't even know who he was. But we found out when we sent a letter to Mr. Lally, while the case was still pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness before the grand jury. It was only after we sent that letter, notifying the prosecution that we were on to Colin Albert, that testimony was elicited that Colin Albert was indeed at 34 Fairview that night. The defense caused this to be revealed, not any investigator of this case. And there's obviously an inference that his name was kept out of the police reports to protect him. The same way Brian Albert is the only person listed in the initial report whose first name is not even spelled out. He's just listed as B. Albert with an incorrect address. There appeared to be a conscious effort of these investigators to hide third-party culprits from the defense. All of these men, Brian Albert, Brian Higgins, Colin Albert, were present at 34 Fairview the night that John O'Keefe was killed, and each had a motive, intent, and opportunity to cause him harm. Now, there are many cases, Your Honor, I know the court is aware of this, endorsing the admission of third-party culprit evidence. Almost all of them allowed in a third-party culprit defense, despite a lack of evidence that the third-party culprit in those cases was actually at the scene of the crime at the relevant time. The first case cited by the prosecution, Commonwealth versus Conkey, Middlesex County case, I remember it from the 90s. It was retried in the early 2000s. In that case, a person was murdered inside a home, just like this case. Unlike this case, however, the defense could not place the third-party culprit at the home when the murder was committed. He lived down the street, and that was enough. Here we have hard evidence, irrefutable evidence, that the three potential third-party culprits were present exactly when the murder was committed. And it's notable that the defense in Conkey, in that second retrial, after the first trial conviction was reversed, the defense was allowed by the trial judge to present a third-party culprit defense, and it wasn't controversial. But the conviction was nonetheless overturned, the second conviction, on appeal, because the trial judge didn't let the defense go far enough in presenting that defense. The SJC ruled that in addition to presenting evidence of motive, intent, and opportunity, the defense in that case should have been allowed to introduce past sexual assaults of the third-party culprit, including one that took place 7 years before the murder. It was reversible error not to permit a full third-party culprit defense,
So this is the part where he's going to get, this case law is going to be the biggest part, because if he's able to give case law about, you know, showing that different convictions were overturned and stuff, there's no judge wants something that they did or something that they decided on to be the reason that a conviction gets overturned and, you know, shit hits the fan. So, oh, sorry, Moose. Sorry, baby. So giving all of this stuff is really important because he's explaining the legal basis for why he should be allowed to present this evidence,
including prior bad acts of the third-party culprit. And I will ask the court to consider Commonwealth versus Finney, a case that I'm very well familiar, as I previously mentioned. I brought that motion for new trial. I argued before the Supreme Judicial Court, and I tried the retrial of that case, so I know it well. The SJC affirmed Judge Ball's allowance of the motion for new trial in that case, ruling that it was ineffective assistance of counsel that the attorney did not raise a third-party culprit defense. The case law makes clear, as Mr. Brennan again acknowledges, that this defense is a time-honored method of defending against a criminal charge. The defense should be given wide latitude to present relevant evidence that somebody else committed a crime. But the main issue in Finney was whether the defense could introduce hearsay to support an already admissible third-party culprit defense. So sort of like Conkey, where, you know, it's just assumed, yes, of course you can present a third-party culprit defense. But, you know, in Conkey, can you introduce unrelated sexual assaults from 7 years before? The answer was yes. And in Finney, of course you can present a third-party culprit defense. But can you also introduce hearsay to support that defense? It was a given. In fact, it was reversible error that the third-party culprit defense was not brought the first time around. Mr. Brennan talks about, well, you can't do this if it prejudices the Commonwealth. That's crazy. Every single time you introduce a third-party culprit defense, you are prejudicing the Commonwealth by definition. You're not going along with their theory of the case. Mr. Brennan's aggrieved that we would deign to present this defense. And I would note, Judge, you know, there's I believe a certain amount of gaslighting going on here in that on one side of his mouth he talks about he wants Ms. Reed to have a fair trial. But we've spent weeks where he's just trying to knock out all our evidence, just limit everything. He's, I believe, acting more like a defense attorney than a prosecutor in that regard. But regardless...
Okay, did I not just say that at the beginning of the stream? Did I not just say that exact thing?
You know, in terms of these cases...
That's funny.
Mr. Brennan said that they all have third-party culprits who have relationships to the alleged victim and or relationships to the scene of the crime. Finney did not. In Finney, my client was the next-door neighbor. My client signed a confession to the murder. The third-party culprit lived several houses away within the same city, but not close, not next door. There was no relationship other than he made statements about how the victim probably deserved what she got and she wasn't the goody two-shoes, but there was no, that she was made up to be, but there was no witness that put the two of them together in any way other than those hearsay statements. Nobody put him at the scene of the crime. The SJC ruled even hearsay should be admissible to support that third-party culprit defense. The defense in this case has more evidence of third-party culprits than the defense did in Finney. We're not asking this court to allow into evidence hearsay, as was admissible in Finney. We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Brian Albert, Brian Higgins, and Colin Albert had. That's the nuts and bolts of a third-party culprit defense. So that's the first issue, presenting evidence of a third-party culprit defense. The second issue is whether we can argue in closing that a third-party culprit is responsible for John O'Keefe's death. That's an issue I suggest that the court does not need to decide now in advance of trial. Closing arguments come at the very end of trial. At the charge conference, this court would be in a position and would be entitled to evaluate the evidence as it came in and to make a decision at that time prior to closing arguments as to what we can argue and what we can't. And while we believe the court has enough evidence now as a result of the first trial and as a result of our proffer and our submissions and oral argument today to rule that a third-party culprit defense is permissible, but this court at a minimum should not deny argument on that issue before evaluating the evidence as it comes in. And that brings us to the final third issue, a Bowden defense. Obviously, attacking the inadequacies of a police investigation is bedrock constitutional law. It's a bedrock constitutional right. In this regard, in one sense, the discussion about the third-party culprit evidence is somewhat academic as opposed to a practical one, because all of the evidence that points to Brian Albert, Brian Higgins, and or Colin Albert, all of it comes in to show the lack of investigation, the lack of curiosity that the police had, and the lack of investigation that they did to rule any of them out. And it comes in to show the bias of the investigators of this case. Bias is also a constitutional right. They were perfectly willing to jump to conclusions about Ms. Reed, someone outside their law enforcement circle, on the wrong side of the blue wall, but very much unwilling to be curious about whether someone within their circle had the motive, opportunity, and means to hurt John O'Keefe. Former Trooper Proctor specifically told his friends he had no interest in investigating someone connecting with law enforcement. And in their internal affairs findings, his superiors noted that his apparent bias was one of the reasons he was fired. You can't have a stronger Bowden defense.
That's a big deal. That's a big deal
So
for
I would
others.
argue, Judge, that the Commonwealth's motion really comes down to what the defense will be able to argue in this case. Our position is we should be able to point the finger of guilt at those who might have done this, but at a minimum, given that the evidence will be coming into trial anyway on the Bowden issue, the court should reserve judgment on what we will be allowed to argue from now, weeks from now, when closing arguments are upon us. This evidence, in conclusion, in our view, must come in. This is a due process constitutional right of my client, and it has to be admitted for two reasons. Number one, it's a time-honored method of defending against a criminal charge by pointing out that somebody else could have done this. And number two, it's a time-honored method of defending against the criminal charge by pointing out that police investigators failed to do their jobs correctly. We have a stronger third-party culprit evidence situation here than existed in either Conkey or Finney, and we assert it would be reversible error for this court to exclude this evidence. Unless the court has further questions, I would rest on my memorandum.
Briefly.
I'm going to choose to focus on case law and the facts that aren't presented by the defense. We see in their motion there's a grand claim that there's extraordinary evidence that John O'Keefe went into 34 Fairview that night. That is critical, because there is no basis to accuse somebody of murdering another person if they don't have the opportunity. In other cases, a third-party culprit is not necessarily found at the scene, even in Finney. It's more than just a couple derogatory words. In Finney, as counsel knows, there was a neighbor who had an axe or a club. He was seen with blood, went home, washed his clothes, wholly irregular, and because of this irregularity and the timing, He was then asked by his then wife about the victim, and he made a number of derogatory comments about her, showing ill will, evidencing, tangentially, motive. And so no, a third party does not necessarily have to be at the scene at the time the police investigate, but they have to be with the deceased if they caused the death. It's obvious. And so we didn't hear any extraordinary evidence, none. We didn't hear kind of good evidence. We didn't hear any evidence. We just have the bald assertion that the data forensic evidence will show that he was in the house. It didn't. It doesn't. They don't have a proffer. So there is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision. The defense's effort to tell a story, take a couple of facts, someone's a boxer, they drank alcohol, and convert it into a story, is how they will try to portray these unsubstantiated facts at trial. They'll tell a story. It will divert the jury's attention. So they're not entitled to it. They're not entitled to it. Time-honored tradition, yes, but there are limitations. Silva Santiago was very clear about the limitations. This latitude is not unbounded. Each of these limitations recognizes the admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth. I'm not whining. The Commonwealth should not be unfairly prejudiced. The people of the Commonwealth should not be unfairly prejudiced, because it is inevitably, it diverts jurors' attention away from the defendant on trial
I'm not whining.
and onto the third party. Essentially, it requires the Commonwealth to prove beyond a reasonable doubt the third-party culprit did not commit the crime. If there was evidence of third-party culprit, the defendant should be entitled to use it. In this case, there is not. There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. Certainly the defense can infer certain facts like getting rid of the SIM card in a way they want, and I don't begrudge that at all. There's different interpretations to it. I understand that. This was heavily considered in the federal investigation, and after that absolute thorough investigation, there were no charges. There was no evidence of third-party culprit. There were no indictments. And so, although we don't know the parameters of the federal investigation and we can only guess as to some of it, we know from what we did receive in review, it was thorough. And if there was third-party culprit evidence, we would expect that there would be a basis for it. It's not an entitlement to simply bring it in under Bowden. I don't defend that there was commentary in the officer's phone that was inappropriate. But that doesn't automatically create a situation where there is evidence that the police officers knew that there was somebody that should have been investigated. In fact, when Mr. Albert came down the stairs, the testimony is the police officer was already inside his home. There's no evidence Mr. O'Keefe, or first responders, was still outside that aid could have been rendered. That is just, it's not only speculative, it's just piecing together different facts and telling a story. So inevitably, while I recognize the case law, there are plenty of cases that talk about third-party culprit should not be admitted if inappropriate. Commonwealth v. Stedman. In that case, a person, not the defendant, was in a fight with a person at a campsite. And then later, the defendant supposedly went back to the campsite, a friend of this person, Royal, and used a knife to stab and kill him. And the defense wanted to introduce prior convictions about the fact that this supposed third-party culprit had attacked people at other homeless sites. Pretty close relationship. A person having a history of attacking people at homeless tent sites. And the court, looking at 403, did not allow it as third-party culprit. They said that the admission would be feeble, pose a risk of unfair prejudice. In that case, there was third-party culprit admitted pursuant to Bowden in a very different way. Commonwealth versus Moore. The court would not admit layered hearsay showing different identifications that were relayed by the police from third parties regarding a culprit. They said that the hearsay was uncertain, the source is unreliable, and it was inadmissible as third-party culprit. So it is not an entitlement to be third-party culprit. Commonwealth versus Buckman, 461 Mass, 2011. The defendant was charged with murdering his wife. When they received a report from one of the defendant's friends, the defendant was softly tied to a pole to look like he had been kidnapped. Inevitably, the police determined that he had help or tied himself as a ruse. And this person, the helper, his friend, had connections to gambling, was there, and when the police couldn't find the body, he knew exactly where the body was. That case is far stronger than many. And in that case, no motive, no intent, and they did not let a third-party culprit defense go forward. Facts suggesting that one side believes a person's telling the truth or not is not facts of third-party culprit. It's just not here in this case. And again, I iterate my position on denying the defense to cross-examine witnesses about these generalizations and these character attacks. I think it will mislead the jury, and it will become a total diversion for the jury, and I don't think the basis is anywhere close. It's feeble.
May I briefly respond? Thank you. First of all, Your Honor, speaking about the federal investigation, when you were not a part of it, and talking about why a federal grand jury was convened, what they were investigating, what they found or didn't found, is complete speculation. It should not be part of this argument. We don't know. It didn't prove anything. It's not as though they came up with a statement exonerating anyone. So that should not be considered by the court. With regard to the two cases that Mr. Brennan cited, you'll note that in one, he talked about the exclusion of hearsay evidence. There's a different standard when you want to introduce hearsay evidence as part of a third-party culprit defense. There need to be substantial connecting links to the crime itself. The court ruled in that case there weren't. In Finney, there were. And with regard to the other case, that's with regard to hearsay. With regard to the other case, that was the exclusion of past assaults to show that somebody was violent. Again, Commonwealth v. Conkey is a case where they said, well, that should be, in addition to a normal or a regular third-party culprit defense, you should also be entitled to that evidence. So that's not very instructive. The other two things I just wanted to point out, because I did not mention them, Your Honor, is that Brian Albert also disposed of his phone, and we'll never know what was on that. That's further evidence of consciousness of guilt. And then an important point is that the plow driver, Mr. Laughlin, went by the house at 3:30 in the morning and saw a Ford Edge parked in the very area where John O'Keefe's body was found. And we know from the evidence that the Alberts, both Brian Albert and Colin Albert, owned a Ford Edge. So that is in the mix as well. And unless the court has any questions, I would rest on that.
All right, thank you very much.
Thank you.
She didn't interrupt them.
On to paper 620, the Commonwealth's motion for production of records regarding unsolved productions.
Okay, so this is, there's no surprise here. Brennan wants all of the stuff from that documentary. I finally started watching it last night, but I haven't finished it. But Brennan wants all of the unaired footage from the documentary to try to use against Karen.
May I?
Yes.
Your Honor, the Commonwealth filed a Rule 17 motion for records from unsolved productions. It has been discussed briefly in court at times during argument. There was a so-called documentary that was aired in a 5-part series. It gave a inside, behind-the-scenes look of the defense team and Ms. Reed as it prepared for the last trial. This 5-part docuseries produces a number of statements from the defendant, many of them extraordinarily relevant, some of them from the Commonwealth's perspective extraordinarily incriminating, and many of them inconsistent with statements made publicly in the past, including Dateline 2020 and to Gretchen Voss. We serve the local service in Boston, a local agent. The record holder is the producer of the series, and they have been notified. If the court allows this motion, I expect they will provide the information to us by the end of the week. I understand there is probably over 200 hours of recorded interviews, and we expect to use a number of those statements at trial. They are statements of the defendant, they're admissible substantively, they're admissible as admissions, and they're admissible to show contradictions with other statements. And so they are material and relevant. I understand the time frame. We haven't had the privilege of seeing them. The defense was there for a part or most of it, but we will use what time we can to sift through it. We're not looking for a continuance or additional time to look at the materials. We'll look at them as we prepare for trial. And so I'm asking you to grant this. It clearly makes the Rule 17 standard. Material, relevant. We don't have access to these before trial. We won't be able to prepare for them if we get them pursuant to a trial subpoena. They've been properly subpoenaed and they are forthcoming with the court order.
There's no one here from Unsolved Productions opposed to this today.
There is not.
Does defense want to be heard at all?
Your Honor, we're unaware of the communications back and forth between the Commonwealth and the production company. So we've not been privy to that. This is the first that we're hearing of any communications that they've had with the production company. I think obviously in an abundance of caution, they should be given an opportunity to oppose if they wish. Nothing official has been filed one way or the other. So we're not in a position to argue on their behalf, for sure.
All right. Let's get that into the Wasser. So, we have two things left to discuss. I want to talk about jury impanelment. We also have a Commonwealth motion regarding Mr. Yanetti's phone. Mr. Yanetti, it's 10 past 12. Which one do you want to go forward on first? Do you want to talk about the impanelment, or do you want this motion?
I'm not handling either of those.
I understand, but do you have a preference what's done before lunch? All right, so let's do that motion. Commonwealth's motion to compel communications between the defendant and attorney will be stored within the defendant's document. Who needs to come in?
No grave concern.
Your Honor, so I'm clear, the Commonwealth is not seeking all communications between Ms. Reed and Mr. Yanetti. We're only requesting the communications that may be on any type of records in the possession of the Commonwealth. And specifically, there are phone records which have been redacted, and I do not know what is underneath those redactions. And we believe we have an entitlement to the information in the narrow area where Ms. Reed has waived her attorney-client privilege. Specifically, where the defendant intentionally divulged the content of her communications with Attorney Yanetti about liability and potentially striking John O'Keefe with her car. Those subject areas in that narrow time frame are no longer privileged because they're now public. The Commonwealth has identified a very narrow window, and that's a 3-day period. And that is what is mentioned by Ms. Reed in her public statements, that she spoke to Mr. Yanetti and she thought about it for 3 days. We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area in which, where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related. This is made in good faith. Anything that is non-privileged is open to the public. It's not confidential. There are two communications that Ms. Reed made publicly that we assert waived the attorney-client privilege as it relates to that issue. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023, and the transcript is page 105, line 23. She was asked the question by Ms. Voss, "You never said, 'Did I hit him?' I hit him." And the answer by Ms. Reed was, "I said, did I hit him?" question mark. And then, you know, when I talked to David, now this is later, David said, "Karen, if you incapacitated him in any way, there's culpability there." And I thought, all right, maybe this is what, maybe I said to my mother, just to go forward for a second, they were asking me, what was it like? Did they come out? What was the house like? Similarly, in the documentary series, Ms. Reed is video and audio taped, and it was presented on television, that she said, "And then when I hired David Yannetti, I asked him those questions the night of January 29th, like, David, what if, I don't know, what if I ran his foot over, or what if I clipped him in the knee, and he passed out or went to care for himself, and he threw up or passed out?" And David said, "Yeah, then you have some element of culpability." So that's how I thought about it for about 3 days. And so that is where I get the time period regarding these relevant statements, admissions by the defendant about her state of mind and her interaction with John O'Keefe in her vehicle. These statements were made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege as to these communications in this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential. Even if it was inadvertent or overheard, it would still waive the privilege. This is entirely different. There can be no doubt that there was an intention to pierce that attorney-client privilege for whatever benefit the defense thought it gained them. This was intentional. It wasn't secretive. It wasn't overheard. It was a exacting and purposeful engagement. So we ask you to review the cell phone extraction, any text or emails that may be on those extractions, and relative to that short window, relative to this specific area, anything that is waived that is no longer confidential, we believe we're entitled to. It obviously would be relevant if it's narrowly related to these statements, and we would use that at trial. Thank you.
I am, Your Honor.
Okay, but also this is not breaking news. Like we've seen, she said it before in other interviews. You know, she said, "What if I hit him?" Because there was something about, I can't remember exactly how she worded it, but something about, you know, she thought, "What if I clipped him?" or whatever. So this isn't breaking news, but it's interesting to. It's an interesting legal argument. I'll say that.
May it please the court. The Commonwealth concedes throughout its motion, as it must, that the communications it seeks to intrude into are privileged communications between Ms. Reed and her attorney, Mr. Yannetti. 2 of the 3 instances of the communication they cite to are over 9 months old. And that's in 5 months old respectively. So you have 9 months ago, the Gretchen Voss statements, and 5 months ago, the Vanity Fair statements. But they waited until less than 2 weeks before the start of the trial to bring this momentous and potentially far-reaching and consequential motion. Why? The courts are clear that they take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privileged communications this close to trial. The Commonwealth does not explain their delay in raising this issue this close to trial. With regard to the third communication, the HBO Max one, it regards the same event that is discussed in the first two. There is no addition of an event in the third one. So that third discussion, the docuseries, regards the same events that have been extant in the first two that have been extant for 9 months and 5 months. The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does. As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client are canonical examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest of privilege for confidential communications known to the common law. And this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context of criminal circumstances, the privilege has constitutional dimensions as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Goldman case 395 Mass at 502. And it bears underscoring the basis and the depth of the intrusion is a quote from the very case and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions, just one. Matter of a John Doe grand jury investigation, 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that the potential is inconsistent with the traditional value our society has assigned, here's a key point, in the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites C. Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in our not factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me, so your motion is denied.
Good for her. Oh, I'm shocked.
Thank you, Your Honor.
Good for her. Wow. Wow.
So, we need to talk about the panel then. The parties need 5 minutes.
She doesn't have a microphone. So she said, for those who couldn't hear her, she said, she interrupted. She said, I'm sorry, I'm going to interrupt you. I know that Brennan is, I know that the request is narrow, but it's inappropriate and I'm not going to give you this communication. I'm going to deny it. So she told Alessi, don't even bother finishing. Brennan, you're not getting these texts. It's inappropriate. So she doesn't have a microphone, so it's really hard to hear. That's why I have these cover my ears and put everything directly into my eardrums headphones, because it's really hard to hear her. But yeah, she that's the first time she's interrupted them for a good reason in a while that I can think of. So I'm impressed.
All rise to the court, please.
You are muted. I'm surprised. I'll be honest. I am. I'm surprised. And like I had said earlier, I don't, for this part, I don't know the specifics on the legal stuff because I'm not an attorney. I just yap about them on YouTubes and podcasts. But I had heard that, attorneys saying that this would be denied. So I'm impressed. I think that it would be a bad idea to grant that, just because that is, it feels so intrusive. It does feel like, okay, if you're waiving, because I feel like, to me, and again, this is just as a juror type perception of this, when I read what he put in that motion about how she's waiving the privilege for these, to me, it seems like she's waiving the privilege for that specific part of the communication because she said it out loud. But it, to me, does not mean that she's waiving the privilege to those text messages. So that's the way that I read it. So I would have denied it. But also, again, 0 law school, 0 years or months or hours in law school, personally. So that's just juror perspective. But I'm impressed. And also, a little bit shocked. Beto brought up a good point, how Brennan is blowing up his career over caring. That's a big thing for me. Because I feel like you are up there losing all credibility right now. And that's, for an attorney, that's scary. Jackie D, thank you for the super chat. Bev deserves a biscuit for that. Taste the biscuit. Taste the goodness of the biscuit. The internet just broke. And she didn't interrupt them today. You know what I bet it is? She went after Alessi and was rude to Alessi last week. And I bet everybody was like, oh, you don't mess with Alessi, ma'am. You want to fuss at Jackson? You want to fuss at Yannetti? Fine. But Alessi is a national treasure and he is not to be messed with. And he's so respectful to her. And so for her to be like, are you about to tell me what you're going to tell me and then tell me it and then tell me what you told me again? She was out of control last week. Maybe she had a good weekend. I had a good weekend, obviously. So maybe she had a good weekend and now she feels better. Maybe. You don't mess with Alessi. Don't messy with Alessi. I got dad jokes. I honestly felt like she was actually joking with him and he didn't take it that way. It felt like one of those mean girl jokes where it's like you smile while you say it so that it can come across as a joke, but you know that it wasn't a joke and it was really just rude. Did she deny getting the unaired footage? Also, just communication with Yannetti. The stuff for the unaired footage, I think she said they don't have a representative there to say they don't want to turn it over, so she'll rule on that one, but she'll probably grant it. She's granted all the other ones. That's how it felt to me. It felt really mean. It felt like she was mocking him. California has a shield law, so Brennan will fail on the footage. What was it? Was it New York that was the other one that he had tried to get and they fought him on it? Because their parent company or whatever it was it New York? Thank you, thank you. Lucy's snoring. Lucy's snoring. So I believe I'm going to do an interview and I'm going to tell y'all now so you can start getting me your questions. I'm going to have Peter, lawyer you know, I'm going to have him on to get some lawyer insight about all of this bizarre stuff happening. So get me your questions, anything that you want to ask to get the legal perspective, anything you want to ask. You should do an interview with Miss McKinney. I've seen some of her stuff that people are posting on, because I'm not on TikTok. I mean, I have a TikTok, I just don't use it. But I'm too old. This old dog can only learn so many new tricks at once. So I have not seen it on TikTok. So I've seen the clips that they're putting on Twitter, and she's hilarious, but also she's so right on everything she says. She's really interesting. She's funny. I am going to be on Aunt Deb. I've got the link pinned at the top of the chat. I'm going to be on with Aunt Deb tonight at 7. So, make sure you check that out. Oh, Britton Ann did a great interview with her this weekend. I can see. Oh, that's awesome. Yeah, I'll have to watch it. I'm hoping that with next week just being jury selection, I'll have a little bit of time to catch up next week. I want to have Peter on with me so that I can ask him some questions, because I'm going to do my plan, if all goes right. My plan next week is to do a podcast episode that's kind of like a catch up for all the people who are just now joining us. Obviously, it's not going to be able to be a deep dive on anything, because you can't deep dive this in one episode. And that's what the other 44 episodes are for. But I would like to do just a quick catch up for the people who are just joining. And I want to use some of the clips from talking to him
You may be seated.
in that.
All right, so I looked at the proposed supplemental questionnaire. They're very similar. So I have a question. So the Commonwealth on your number 5 on the first page. I don't like the 2 questions in a row, 4 and 5. I don't think we need 5. Is that okay with you, Mr. Brennan? I don't think we need both.
It should be done.
Yeah. So that's out. So I'll go through, actually I'd like to go through the first page of each. The first page of the defendants, number 13. Do you believe law enforcement officers are generally fair and accurate in their investigations? Who's arguing this for the defense?
I can argue it.
All right, so I don't have a problem with that, but it makes sense that we put it after 8, those series of questions.
No objection to that.
All right, any objection to question number 13 and putting it at 9, Mr. Brennan?
I don't have any objection to moving it after 9. I think it's a bit one-sided. It leans towards one-sided, but I don't have a strong objection to it.
And we can balance it if you want to suggest some language.
If there's an invitation to balance, I'll need a moment.
All right, so you
I
can
can't agree.
suggest something
Okay.
at some point. All right, so now moving on to the second page. The Commonwealth's number 17 seems appropriate to me, but if you were working for the same document, it's not in the defense when it was removed, I guess. Is there anything about crash reconstruction testimony that would make it difficult for you to be fair and impartial in this case? I don't have a problem with that question. Does the defense?
We didn't have a real objection to it. It just wasn't a particularly useful question. We thought of the last trial. Everyone said no. So in furtherance of trying to have additional space for more helpful questions, we just decided to exclude it.
All right, I think we'll keep it. There's one I do want to get rid of. It caused problems last time, but we'll talk about that in a minute. All right, so thank you. So question number 23 on the defense.
This is for the jury questionnaires.
Object to that question? I think it needs to be tweaked at the least just a little.
We do.
All right, so what's the objection?
question, the way it's written, invites a juror to potentially not follow the judge's instruction. And so I understand the attempt, the idea of it, the germ of it, but the way it's written, it invites, I think, a jury to, or a juror to usurp what their role is.
And what are you saying, Ms. Little?
I think if we just tweak the language a bit, I mean, we're happy to hear some proposals from the DA as to sort of the particular issue to have with this question. But I do think the question about the judge's instruction regarding, you're entitled to your own independent and individual verdicts.
So they're always told that their verdict must be their own. So there's language in there's probably language in my preliminary instructions, there's language in the charge, certainly. So if it mirrors that language, I don't have a problem with it. Otherwise, I might. So
We can mirror the
talk to each other about
court's
that.
charge.
All right, so,
We would agree to that as well.
okay, thank you. Number 25 in defendants. If you had to vote today on whether Ms. Reed is guilty or not guilty of the crimes charged, what would your vote be? I tell them throughout the trial they're not to speculate, they're not to make up their minds until all the evidence is in. I'm not going to even suggest that this is appropriate. So I'm not going to include that. There are enough questions on reasonable doubt, presumption of innocence, and defendant not testifying. So that's out. So the question, also, is there any reason why you do or do not want to serve on this jury? I don't think we should invite them to decide whether they want to sit in this jury or not. I think we did give this last time. I don't know what the responses were. Does anybody have any information on that for me?
I think most of them were no. I think 27 kind of hits the same sort of, if
Right,
you have
if that-
general concerns about the case, so I don't have a strong objection to
If that's what we're getting at, we've got it in 27. So I'm inclined not to put it on there. Again, I can hear from you beforehand, probably in writing, I don't want to bring it back.
May I alert the court's attention, there's two on the first page that were slightly worded differently in the Commonwealth proposed questionnaire and the defendant's
Oh, okay, which
proposed
numbers?
questionnaire. If the court looks at number 4 on the defendant's questionnaire, we had kind of combined the Commonwealth's proposed questions 4 and 5.
Yeah.
So that it's one question.
So that's, and I just got rid of Commonwealth 5.
Perfect.
So this one's better, so we will use that.
Okay, and then number 7 that was proposed by the defense, that is the similar question as number 8 in the Commonwealth's proposed questionnaire.
Yes.
It's just different language.
I thought it was the same.
So we changed it to say, we tend to believe or disbelieve law enforcement officers, firefighters, or first responders more than a civilian witness simply because of their occupation, as opposed to automatically believe.
So we typically ask the automatically, what's the Commonwealth's position on this?
I have a strong preference, I'll defer to the court.
All right, so I will think about that, Ms. Henry.
Thank you, Your Honor.
This is for the juror questionnaires.
Question that I don't like, and you remember, causes a lot of jurors to say, I have no idea what you're talking about. 21 on the Commonwealth, 20 on the defense. So you may find a defendant guilty based on circumstantial evidence, but you cannot find a defendant guilty based on speculation, guesswork, or surmise. Is it difficult for you to understand the difference between circumstantial evidence, speculation, guesswork, and surmise?
I'm sorry, can you repeat that?
It's your number 20. I'm not going to read it again. It caused a lot of trouble before. I think in every single one I had to repeat myself with the instruction that I gave in anticipation of this. I gave them a pre-charge on circumstantial evidence and not being able.
Yes, just the way that it's phrased in the Commonwealth's questionnaire makes it seem that the Commonwealth doesn't have to meet their burden of proof.
I think it should be omitted completely.
I have no issue with that. It's just the way that it's
Does the
phrased in the
Commonwealth?
Commonwealth's questionnaire.
It's too confusing in my mind.
Okay, it took up, if you remember, it took up an inordinate amount of time with virtually every single juror.
We have no problem with that.
All right, so that would be omitted. All right, so that sidewalk the other day. The third page was right from Chisholm. I reread Chisholm, 95 pages of it the other day, and I didn't see it. Where does this third page come from? The publicity one.
The questions come from Chisholm that were asked in the juror questionnaire. The other, some of the other cases, questions were part of the juror questionnaire in the prior trial that just moved over to this page. So this page dealt with a questionnaire exclusively of pre-trial publicity.
Okay. All right. I think that we all know many, if not most, perhaps all, potential jurors have heard about this case. Giving them
Yeah.
the opportunity to write the details that they would call down may take an awful lot of time and space that we don't have on this form, and frankly, I don't think we have. So, what are your positions on, what's your position on 3?
Your Honor, if I may, I can just hand up the excerpt from the Chisholm case that outlines the.
All right, I'm not sure 2 lines are enough space for it, frankly. All right, I guess we'll see what we can do. I didn't realize it came directly, same language. Okay, looks like we're giving this third page of the questionnaire. Yes, Mr.
Your Honor, I want to bring to the court's attention something about the court and counsel just discussed question number 7. Could I ask the court to direct its attention to question?
Which page?
Sorry,
Current page or previous page?
the defendant's questionnaire on the first page. That was the question. I think the court's going to consider whether to use the word automatic or tend to.
Yeah.
I believe that should be broken into 2 questions. It doesn't tell us anything. For instance, the way it's written in the disjunctive, would you tend to believe or disbelieve law enforcement officers, firefighters, first responders, more than civilian witnesses, just simply because of their occupation? If someone says yes, we don't know if that's believe or tend to disbelieve. So I think if we just break it into 2 questions and now we've got the space to do it, that would be more instructive.
Why does it matter if it's an automatic belief?
I'm not worried about the automatic part. It's the believe or disbelieve. That's the part that doesn't help us.
Right, so if it's automatic, simply because of a person's occupation, this juror would automatically either believe or automatically disbelieve. How does it make that person a fit juror? Why do you need it?
Because that tells us, it would instruct me at least, it would enlighten me on how to further question that juror. If someone says, well, I'd automatically disbelieve police officers, or I'd automatically believe police officers. Those are 2 very different mindsets.
So I understand that. I'll consider it. I think we keep it as 1, and then if they say yes, we inquire it.
Okay.
Maybe. Let me see.
Okay. Thank you.
All right, so it looks like we have the third page as well. I think, I have the statutory questions that I would ask of the Nairi.
Thank you.
If we take that question that Mr. Jackson just talked about, I can ask each individual juror, if I use the tend language, if the testimony were in conflict, would you tend to believe the testimony of a police officer more than any other witness simply because he or she was a police officer? And then conversely, would you tend to disbelieve a police officer simply because he or she is a police officer? I typically do that at sidebar in every case, asked exactly like that. So it makes more sense to me that we do it that way rather than a questionnaire. But if you want it on a questionnaire, it will stay as is. So what's your thought, Ms. Lynn?
That would be the defendant's preference.
Do you care, Mr. Brennan?
We prefer a questionnaire.
All right, so I'll think about it, I'll do it one way or the other, and you'll know next week. So, one of the things that I was considering doing, so we have a lot of jurors coming in next week. On Tuesday, 218 jurors have been summoned, is my understanding.
218 for
We'll let
Tuesday.
some portion of that. We will get some fraction of that maybe, just on how it goes with whether people are here and available to testify on that date, to serve as jurors. So say we get like 150 or 175 jurors. I have my remarks to sort of just direct them to what their job is, as you remember, and then I leave and I give them the questionnaires. My guess is for the jurors to fill out this questionnaire, have the questionnaires collected and copied, might take an hour and a half or 2 hours if we have a really large number of people. What I intend to do, at least on Tuesday, is have all the jurors fill out the questionnaire, however long that takes. And depending on how many jurors we have and what time it is, maybe take 50 of the last jurors or so, send them home, and have them come back the next day at 11 o'clock. If we've got fantastic court security here, hopefully we've got a courtroom to keep people in. There are a lot of things we have to juggle to get this done, and I don't want to waste jurors' time. So I would send them home, have them come back the next day at like 11, so that then the next day's jurors at 11 o'clock can spend that hour and a half, 2-hour process, filling out the forms, having them copied, given to counsel, and we can continue on with those jurors. So it's something we can decide on Tuesday when we see how many people are here, how many jurors we get, how many jurors the district court needs. But is that a process that you would be willing to do? Mr. Brennan?
Of course. No objection.
All right, so we'll try and figure out something that way to get things moving that way. All right. The list of witnesses. You both have a list of witnesses. I told you you needed to combine them so that I can read that to the jury, the statement of the case to the jury. Do you have that yet?
No. We have not combined them.
All right. So I need you to look at that and a statement of the case to read to the jurors. It's all part of the final trial conference. So I should have had it last week. So I need that by Thursday. Is there anything else we need to discuss today?
There's still a few outstanding issues. One is ARPA. And
Where do you stand with discovery on that?
I received some TUI letters last night. It is not the information I was seeking from my motion that was allowed by the court. And so I have grave concerns about waiting for the day before they testify.
Grave concerns.
Yeah, the discovery that I think I'm entitled to.
What do you say, Mr. Jackson? James Jackson.
Your Honor, I do not know what Mr. Brennan is referring to with regard to what he's looking for and grave concerns. The hyperbole is unnecessary.
So there was a motion allowed, so that should be able to, there was a motion for the discovery allowed a while back.
It
So
was.
that should narrow.
Right.
Right?
Pardon me?
That should narrow things.
It does, and we have not, I attempted to confer this morning with Mr. Brennan, and my recommendation to the court would be for us to confer further, because I just don't understand what he thinks is out there, but we haven't conferred fully either.
Okay, all right, so do that, we can address this next week. I think we're going to have plenty of time to sort of tie up loose ends during the impanelment process, because I think it's going to take a very long time to get a jury.
Understood. And I expect we'll file a response to a proposed expert. We received a report last night and received it until later, which I want to have a chance to respond to.
And Your Honor, if I could, please, one more item when it's appropriate for Your Honor.
That's okay, go ahead.
Thank you. We did receive the, Your Honor may recall the argument over Dr. Welcher in Your Honor's direction request, and then the assent of the Commonwealth that they would redo what they had provided, that 140-slide presentation. We did receive that, but we received a lot of other material in addition to that, huge megabytes. I haven't even been able to open it up. It takes so long to open it up. I respectfully request that we, Your Honor, grant us please 2 more days than what we had to take a look at that, because it's just taken an extraordinary amount of time.
Makes sense, Mr. Brennan?
I can be clear, there's no new information. What Mr. Welch did is that all the information he basically gave his opinions on was in the gigabytes we provided to the defense, but he wanted to make it as seamless as possible, so to effectively hold their hand through it, he put each site under each slide so they can find it in the file folders exactly where it is. So it's instructive and helpful, but it's not new.
Your Honor, if I may, I don't disagree with Mr. Brennan's characterization. However, it is still 140 slides or so. I was expecting a rather substantial narrowing, so what we have to do is we have to go, and unfortunately, I think Your Honor is going to hear similar points that we made, but it's going to take more time, because I had the expectation, maybe unreasonably so, that it would be a narrowed slide presentation.
He said
So
that.
I appreciate the 2 extra days.
He said that.
So when does that put us at? What was the time frame originally?
I'm sorry, Your Honor, I don't have the specific date handy right now.
The time frame as far as the response?
Yes.
Well, we were supposed to exchange discovery yesterday. And so I had that presentation sent over last night. They sent over the 2 letters. And
Okay, but Brennan said that 140-page thing, that they're not going to use all of it. And there were so many things in there that he knows that they can't use. Like, he can't talk about the witness testimony and things like that. And he was supposed to pare it down. So he didn't?
I received the third dog experts report.
If I could, Your Honor, I maybe Attorney Brennan misunderstood the question. He is correct that he provided us with the presentation last night, but the question, I believe, Your Honor, was when was our time, because Your Honor had given us time to respond, and I apologize, I don't have that date, but what I'm just asking for is 2 more days beyond it, but
I don't think I gave it to you.
yeah. Okay.
So you have 2 days to respond to that?
I have 2 days from today?
Yes.
Okay.
All right.
Dang.
So there are a few matters outstanding. I will have the decision on the motion to dismiss, should by the end of the day, buffer zone, probably by the end of the day. And I'll get everything else done as quickly as possible. All right. Anything else?
The only other things that which is an issue as it pertains to both the voir dire process as well as during the trial, I wanted to ask the court if there was a mechanism by which Ms. Reed could have at counsel table some sort of an earpiece or headphones or something that's slaved to a microphone up at the bench at sidebar so that she can listen in on both. It's very. I want to avoid that if possible. It's clunky. Especially during the voir dire process. I think it would be uncomfortable, and quite frankly, I think it would be a little inappropriate to have jurors with Ms. Reed standing right there with them and with us.
It's done all the time.
It may be done all the time, but
It may be something you're choosing not to do, but she has every right to be there at sidebar. So you say you don't want that, you want some accommodation. I don't know if we can do it. I'll think about it.
we could. One of the things that we were talking about is potentially a closed circuit wireless microphone up at the bench and a set of headphones here that she can listen in on.
Put it all in writing. I
Okay.
would like to have had it before today. We've been moving around courtrooms. It may not be able to happen.
Okay.
All right, so the alternative is she can come to sidebar for any sidebar discussion, impanelment, whatever. It's her absolute right. If she chooses not to do so, I'm going to need you to tell me that.
I'll put something in writing and perhaps I've got the plan in the back of my head. I'll put it in writing. And
We have a lot of different equipment that we need to make sure has priority. It's in the
Understood.
courthouse, so I'm not very hopeful that we can accomplish this in the next few days.
Okay, well, thank you for entertaining.
All right. One thing, when we get the juror questionnaires, the supplemental juror questionnaires that we talked about, and I need you both know what my decision is here, other than the 10-2 versus automatic. Let's go with 10-2. And I can either do that at sidebar or in the form. What I'd like you to consider, and lawyers have done this in other cases that I've had, is if there are answers that are clearly what you believe would both sides agree jurors excused for cause. In an effort to be able to go through this vast amount of jurors that the jury commissioner's office was kind enough to summons in for us, if things stand out to you, it would be ideal if you could agree that jurors number 8, 12, and 16, both sides agree should be excused for cause based on the supplemental questionnaires. It would be very helpful if we could do that. And maybe keep a running sheet that would be a joint proposal to excuse these jurors for cause. It may happen when you look through the questionnaires on folks that we sent home to have them come back the next day, to just call 5 people, the court officers call them and tell them not to come in based on their questionnaires. So please think about that. It makes sense to me. It was very helpful when lawyers were able to get along well enough to do that in a case that we tried, that we had changed venues on because of the pre-trial publicity also. All right, anything else?
No, thank you.
Your Honor, there was a motion for reconsideration that was filed with regard to the metadata underlined. I can.
You can make an objection. Go ahead.
I just wanted to make sure that the court saw that motion and that it was filed. I don't know if the court wants to hear a oral argument and have to do that, but we just wanted to make sure that that gets decided.
Okay. All right, there's still a few months here.
Thank you.
All right, anything else?
Nothing to say.
All right, we'll see you on Tuesday.
Court, all rise, please.
Okay. Goodbye. So, what are we thinking? How are we feeling? Hurt my ears. So, highlights of the day. Tell me in chat. Highlights of the day. For me, her interrupting Alessi and saying, you don't even have to go any further. Brennan, I'm denying your motion. You're not getting those texts. That was the highlight of the day for me. So you tell me what you think. That was a highlight for me because that was... Bev needs some mods in the courtroom. Ain't that the truth? Bev not interrupting, that's a good highlight. But like, and the one interruption that she did was actually a good one and for a good reason. Go figure. How often does that happen? Like never. Yeah, that was amazing. Yeah, Sheila says, what's irritating for me is that she said that a decision on the motion to dismiss will be coming today. Later, she said, see you on Tuesday for jury selection. Gee, I wonder what her decision is. Yeah, it's like waiting till the last minute to deny this. So then you just move on. Yeah. I am actually shocked that I'm not shocked that she is denying the motion to dismiss because I'm not shocked about that. But not giving an evidentiary hearing on this is still crazy to me because I feel like there are so many things that need to be explained. And how can you let evidence in without people in the courtroom under oath saying their role in this before? Like, the authenticity of a lot of this evidence is in question. So I don't know how you cannot have and I don't know. I'm confused what she's doing with jury selection. No voir dire, no questions. Yes, so they are going to do that. So they're doing the supplemental questionnaires. So because they have the way that I understand it from what they're saying is they're going to have them fill out these questionnaires. And then after they do that, then they're going to have questioning and kind of going from there. The questionnaires are because okay, so they don't want to do a panel voir dire because then it's like you ask something in front of a panel and then you can't unring that bell. So if somebody says something about like, yeah, I saw this, on TV and, she was framed, or I saw this on TV and she was, she's guilty or whatever. Like if they say anything that could potentially end up making them have to send that whole panel that they're questioning home, they want to avoid that because of all the publicity on this. So what they're going to do is they're going to have them come in, fill out these jury questionnaires that has all of these different questions on them, and then they're going to have them talked about at sidebar, or talk to rather, get on sidebar and talk about the jurors, talk to them and ask them questions at sidebar away from the other jurors. So the juror questionnaire, she says if there are, like, let's say that this one question is, if anybody that answers yes to this, if both sides agree we should strike them, then that would save some time because then they can go through the questionnaires and be like, oh, if they answer yes to questions 7, 8, and 9, then they're a no-go. Or if they answer no to 4, 8, and 12, or whatever it is. So that can kind of make it to where they're able to get it narrowed down a little bit to save some time. Because this jury selection is going to take some time, y'all. If it took 2 weeks last time, think about how long it's going to take this time. Right? But I'll be honest, I have the questionnaire. I haven't looked at it yet. Let me pull out mine. Let me see. I have the questionnaire. I don't know if I have it saved on my computer. I know I have it saved on my Remarkable. Okay. You want to hear some of the questions? Hey, Virginia, the only ruling she made today is that Brennan is not getting the text that he wants from between Yannetti and Karen, which I think is a great ruling, but also I'm not going to lie, I was surprised. But that one is, I think, the only one she ruled on. But she did say that she's going to issue some rulings later. Okay, so here's the questionnaire that was proposed, which this is the one that was on here earlier. Okay, number 1, it is alleged that on January 29th, hold on, let me get my old lady glasses. Old lady glasses are dirty. Okay. It is alleged that on January 29, 2022, while intoxicated and operating her motor vehicle in Canton, Massachusetts, the defendant, Karen Reed, killed her boyfriend, John O'Keefe, an off-duty Boston police officer. Is there anything about the description of this case, the charges, or the victim, or that the victim was an off-duty police officer that causes you to believe that you cannot be fair and impartial about this case? I mean, I feel like if that's a yes, then that one should be an automatic no. Okay. But, yes, no, and unsure are the options. 2, have you already started to make up your mind about this case? 3, do you have opinions regarding previous experiences as a juror, the fairness of the jury system or criminal justice system in our country that would impair your ability to be fair and impartial to both the Commonwealth and the defendant? Number 4, do you have any religious or philosophical beliefs that would make it difficult for you to follow the trial to come to a verdict in this case? 5, do you have any religious, do you have any religious or philosophical beliefs that would make it difficult for you to be impartial? What religious belief would make you be impartial? Like, my religion is that everyone is always guilty no matter what. Or maybe my religion is that I don't judge, so I'm just going to say not guilty. Maybe that's it. I don't know. Chat, let me know. My brain is fried these days, so I might not be thinking about things clearly. The case is expected to garner this is number 6. This case is expected to garner a significant amount of media attention. Is there anything about the high-profile nature of this case that would prevent you from serving as a fair and impartial juror? See, on this one, I would have to be like, yeah, if it's like in the media a lot, yeah, I can't be impartial because I'm gonna be wanting to gossip about it. I'm gonna be on the internet. I'm gonna be out on these YouTube streets, and I'm gonna be talking about it. So that's a no for me. Okay. This case is expected to garner a... Oh, wait, I just said that one. Yes. Do you, any family members or close friends reside in or conduct regular business in Canton, Massachusetts? Would you automatically, this is number 8, would you automatically believe or disbelieve law enforcement officers, firefighters, or first responders simply because of their occupation? Do you have, number 9, do you have any strong beliefs? I'm looking at y'all's answers. I'm not just like freezing mid talk like a robot. I was looking at y'all's answers. And then I forget that when I stop and just start looking at y'all's answers, then y'all probably don't know what the heck I'm doing. Okay, so do you have any strong personal beliefs or have you been exposed to any strong personal beliefs from friends and relatives about law enforcement officers, prosecutors, or the government? Number 10, have you ever been involved in a group, community, or individual activity showing support for law enforcement or in or outside your own community? Number 11, have you ever been involved in a group, community, or individual activity that was critical of police or law enforcement in or outside of your own community? 12, have you or someone close to you ever had education, training, or work experience in any of the following fields? Law enforcement, military, alcohol, drug abuse, or domestic violence? Number 13, do you have any strong personal beliefs or have you been exposed to any strong personal beliefs from friends and relatives about operating a motor vehicle under the influence of alcohol? Yes, these cops are dirty. Yeah, I know a lot of us, like, we would be on that list of automatic get up out of here, y'all, because we'd be like, oh, we got opinions already. Have you ever been involved in a group, organization, participated in a march, demonstration, campaign, or donated money on behalf of an organization or cause that was against drunk driving under the influence of alcohol, such as SAD, which is Students Against Drunk Driving, or MAD, Mothers Against Drunk Driving? Number 15, has anyone close to you what kind of psycho doesn't have strong beliefs about operating under the influence? Well, apparently pretty much everybody in Canton. Has anyone close to you ever been involved in an incident involving drinking and driving? If so, would that experience prevent you from being a fair and impartial juror in this case? Number 16, have you or has anyone close to you been involved in or witnessed a motor vehicle crash? I feel like that would be most people, right? Haven't most people either been in or, what did it say? Been involved in or witnessed a motor vehicle crash? Pretty much everybody has, right? I would think so. Number 17, is there anything about crash reconstruction testimony that would make it difficult for you to be fair or impartial in this case? That's an interesting one. Is there anything about crash reconstruction testimony that would make it difficult? Let me highlight this one because that's very interesting. Crash reconstruction testimony that would make it difficult for you to be fair or impartial about this case. That's interesting. 18, have you or any family members or close friends been involved in a domestic violence relationship that featured physical, mental, and or verbal abuse? Number 19, have you ever been the victim of a violent crime? Number 20, during trial, you will hear testimony about medical treatment, death, and review graphic autopsy photos. Will that affect your ability to participate and be a fair and impartial juror? Number 21, you may find a defendant guilty based on circumstantial evidence, but you cannot find a defendant guilty based on speculation, guesswork, or surmise. Is it difficult for you to understand the differences between circumstantial evidence, speculation, guesswork, and surmise? That's an important one. So if Trooper Paul doesn't make sense, will that be a problem? How do you feel about Super Troopers? Megan Easton, hello. I'm sorry, are we officially a thing? Huge. Oh, yes. Hi. Yes, it's official. Yes. Thank you. Okay, number 22. If the defendant doesn't testify, do you think she is probably guilty or hiding something? Number 23. Do you know or recognize anyone you have seen today in the courthouse or in the jury pool? Number 24. Would your answer to any of the above questions be embarrassing or damaging if disclosed publicly? Or would disclosure infringe on your privacy? That's an interesting one too. It's like, hey, it's crazy out here in these Karen Reed true crime streets. So if any of this is a thing. Do you have any concerns about your personal privacy due to the presence of video cameras in the courtroom and or the highly publicized nature of this case? Number 26, is there any reason why you do or do not want to serve on this jury? I'd be like, the money, bro. Like, isn't it like $16 a day or something like? And also that it's going to last forever. And also that she'll threaten to turn the fan off if. Okay. All right, here's the, I think this is the supplemental one. This is the, okay, number 1, do you have any knowledge of this case gained from any source? Yes or no? Number 2, what is your source of knowledge? And then you can choose, there's like a thing. Wait, can you see that? No, it's blurry. I don't know how to make it not blurry. What is your source of knowledge? Television, radio, newspapers, magazines, internet, Twitter or X, social media, Facebook, Instagram, TikTok, other, podcasts, like 13th Juror podcast, available anywhere you get your podcast, family, friends, observations in the community, overheard discussions, or other. Carrier pigeon, rubber duckies, honeymoon fund. Thank you. Thank you. Who knew? Right, and Brandy Churchwell told me. Yeah. YouTube streets, that should be an option. Let's make our own, like hold on, we'll make our own and we'll send this to the judge. So let's make, okay, so we're going to add in YouTube streets. Out in these YouTube streets is the more proper way. Out in these YouTube streets. Okay. So that should be one. Put my little box there. We're just going to add it in ourselves. Duckies, rubber duckies. Okay, we're going to add that one in. Rubber duckies / litter. That's one. Speak up or the AC gets it. Yes. Brandy Churchwell told me. What else? Wiretapping. We'll go with it. Wiretapping. Standouts. TB Daily News. What is he? I've seen him put out. What's he call it? He started making fun of what they call him. He started putting something about the Turtle Club sex cult or something. I heard about it in the Turtle Club sex cult. Okay, got it. What if somebody did put other and then that's what they filled in? Heard it at CF McCarthy's. Okay. The band at Waterfall sang about it. Waterfall band. Someone butt dialed me. There's so many options, y'all. Yeah, someone butt dialed me that's an important one. Yeah, written on the high top tables. Written on high top tables. Okay, that's a good one. That's a good one. Read it on Higgins' destroyed phone. Oh, the basketball game. Canton High School girls basketball game. Yeah. The Stop and Shop. That's a good one. Stop and Shop. We're running out of room, y'all. There's so many places that the jurors could hear about this. Chris Albert Street Cam. Good one. That's a good one. We need to add that one. D&E Street Cam. Getting all the deets. Speaking of which, do you think the street cam, remember how we heard that there was potentially a video of the juror who got dismissed, but nobody ever produced one? Would that be wild if it was D&E street cam? Wouldn't that be wild? Heard it from the snowplow driver. From the weed whacker. And then he wouldn't be able to actually, the reason it couldn't turn it in is because he's not supposed to be, I don't know, just a thought. Okay. Moving on. Wouldn't that be weird? Wouldn't that be wild? All right, what are the details of the case that you are able to recall? We're going to be here for a minute for that one. Be like, hold on, let me pull out my spreadsheet. Are you aware of any specific impact this criminal allegation has had on your community? Yeah, everybody hates each other and there's rubber ducks everywhere. Rubber ducks everywhere. Everywhere. What is your primary source of news and information? Plevin. And Coffin Dapper. How often do you read print or online newspapers, magazines, blogs? And what sources? How often are you exposed to news from radio, television, podcast, or social media? And what sources? Some people, that is their source of information, and those are the people that I pray for. All right. What is your familiarity with this case prior to today? Have you had discussions about this case prior to today? Is there any reason you would be unable to follow an instruction that during your jury service you may not read any news or media accounts about this case, watch or listen to any media or news broadcast or commentary about this case, discuss this case with anyone, research or look this case up on the internet, or perform independent research? Y'all know me. First thing I'd be doing is like, y'all, I'm gonna make a spreadsheet. So I would be out on that alone because I'm gonna be like, look, I need all the details. I'm gonna be like on their, sisters, cousins, dog walkers, grandmas, Facebook, getting all the tea. So I'd be out. All right. Is there any reason you would be unable to follow an instruction that during your jury service you may not? Oh, wait. Did I just do that one? Is there any reason that if you are... Oh, no, wait. That was a different one. Okay. Is there any reason that you would not be able to follow the direction to... Okay. So you can't read or view any social media articles, posts, videos, podcasts, or other non-traditional media platforms that may discuss this case. I'd be like, excuse me. I'm nosy, and I like to be all up in that and see what's going on, and then make a spreadsheet about it. So can I go home now? Is there any reason that if you are inadvertently exposed to extrajudicial influence or media about this case, that you would be unable to follow an instruction that you must report an exposure to a court officer or to Lieutenant Fanning? I'm just joking. I made that last part up. Fake news. And then there's like a whole blank sheet. Can I tell you what I am using? Oh, this thing, it's a Remarkable. It looks like a... I don't know how to make the blur thing go away. There it goes. The composition, it looks like a composition book, but it's actually a Remarkable. It's great because I can pull up all of my court documents on here and highlight and make my notes and all of that stuff, and then like flip through them. Wrong way, because that was the blank sheet. And then flip through them. So that way I'm not stuck at my desk when I'm going through all the court documents. I can actually sit outside and do it, or sit on the couch or somewhere that's easier on my back, because I spend so many hours at this desk. So that's that. I love that thing. I love it. I love it. Love it. Love it. Going through the court documents is the big thing for me. And I'm very much like, I like to write my own notes, like old school style, but I also don't want to kill all the trees. So this is perfect because I can put all my documents on there, make my notes, organize them, all that stuff. Oh, EDB has one and loves it. Yeah, I love mine. I love mine. And I can take it out to the beach. So if I'm reading transcripts or documents or whatever, you can see it in full sunlight. So I'm dismissed for being engaged. Shit, I'll be like I got a wedding to plan all of a sudden. Oh, that sounds weird saying out loud. Megan Easton, it's good to see you love with people. I'm going back to start from the beginning. Enjoy. Oh yeah, send questions. Okay, let's do it this way. Let's do mods. If y'all can make a thread for that in the Facebook group, and then everybody can put their questions in like on that thing for Peter, for Lawyer You Know. Because I can try to do them on email too. It's a little bit harder sometimes for me to do it on email lately because I'm getting so many emails. But if y'all can make a post in the Facebook group, and then everybody that, if you have a question that you want me to ask Peter, any kind of the legal input on anything, let's get his expertise, then if you'll comment on that post, then I can go pull him. Thanks, y'all. Thanks. You the best. You the best. He said Chat Daddy didn't ask for her approval. Tell her I'm sorry. But he did ask my kid and my mom. So 2 out of 3 ain't bad. Oh, perfect. Or if you don't have Facebook, you can DM me on X. And I will send them to Brandy. Thank you. That's perfect. That's perfect. Yeah, I'll find out when for sure it's going to be. I think it's going to be Monday. But I'm excited to get his input on some of this because this is one of those that is just a crazy, crazy case. And by then we'll have some of the rulings on the other stuff too. So. I just knew he asked your mom and son. Yeah. Isn't that sweet? I didn't know that either. It'll be on this channel. As long as we can get it worked out. So that's the plan. I think that's it for now. I have already released the episode for this week. I will do another short episode later in the week that covers just the stuff from today, and then any of the decisions that are made by the judge between now and the end of the week, anything I can get in there. So I can't believe jury selection starts in a week. Crazy, right? Crazy, crazy. Yep, court is over for the day. So we'll hear from her later today about the, what'd she say, the motion to dismiss one and the buffer zone one. She's supposed to release those today. But there will be the third-party culprit thing that they argued today, the motion from both sides, the motion and opposition have been filed. So that'll be a large portion of what the episode is this week. So we'll see. I mean, she's got a week before jury selection starts. So I'm assuming some of these things will be brought up again next week before the jury comes in. Any final motions? I feel like I'm going to sneeze now. I'm allergic to y'all. Oh, I'm not allergic to y'all. I love y'all. All right, so I'm going to call it a day. Oh. All of a sudden, I'm like, yes, the Anti-Deb. I will be on Anti-Deb. Oh my goodness. I'm going to sneeze. I'll be on Anti-Deb at 7 tonight. So y'all come join me. That'll be fun. And the link is pinned at the top of the chat, so you can check there. Debbie Long, member, 22 whole months. Love our family here. Thank you very much. We love you. We love you. Gretchen, Brady, has Karen Reed's team asked for a copy of your timeline to use as a visual for the jury to follow? You have been, they have access to my timeline. Laura, I'm pretty sure Laura, will be, I've got to figure out the details. I'm pretty sure it's going to be live if we can get it worked out. If not, then it will be recorded and I'll use it in the podcast, and then I might just do it as a premiere or something. But it may, I'm going to try to do it to where it's alive. So we're trying to work it out now. All right, I think that's it. I appreciate everybody hanging out. I appreciate it. So much big stuff happening lately. It's been a crazy few weeks, but it's all good in the hood. Let's see let's crash somebody's party. I'm going to send y'all, let's see who's live. I'm going to send you to crash somebody's party. As I continue to sniff and sneeze all of a sudden. Edit. Redirect. Oh, Baker and Valhalla are live. All right, I'm going to send y'all there. We'll go say hi. All right, so everybody, hands and feet in the portals. We'll pop over there, say hi, crash their party, and I will see y'all again very soon. I will put in the community tab when I figure out exactly when the next stream is going to be. I'll put it in the community tab for y'all. All righty. All right, I love you all.
I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel and
Good morning.
Goodbye, good people. Now, how the heck do I get out of here?